Welcome to our live webinar, Ask ProVisor. This is transparent talks for real estate professionals. My name is James Mercado. I'm the president of ProVisor. I've been in the business over 25 years. Love it. It's crazy. It's a challenging market right now, so that's why we're doing this. We want to help you differentiate yourself and bring value through your expertise, your knowledge, so you're better equipped to serve your clients in this market. We're going to get through it one day at a time. We want to tell you, if you have questions, you can email them to james@provisor.com. We take live questions during the show. Today, I'm blessed to have a special guest. This is attorney Elisa Ruhr. Sorry. Oh, she's a longtime attorney. She's well-versed in real estate and mortgage. Tell us a little bit about you and what you do.
I've been practicing for 27 years. And
27 years? Did you start in kindergarten?
Okay, that's a good way to start this.
Okay, good.
Basically, I handle mergers and acquisitions, people buying and selling businesses,
Okay.
which always, most of the time, involves real estate, and then commercial and sometimes residential.
Okay.
I started out, though, out of law school at Evergreen Title. I was corporate counsel there.
So you're an attorney for a title company?
Title inside and out.
Okay.
I love it. And then I worked for a mortgage company, USA Funding, for 7 years.
Okay, so you're corporate counsel for a lender as well.
Correct.
So I would say you're probably qualified to answer some tough questions today.
We'll try.
All right, well, we're glad to have you here as an attorney. Welcome to Elisa. Welcome to our online audience. This is going to be very good stuff because everybody thinks they have legal answers, but we actually have a lawyer in the house today. So first question, when you have to help a realtor as a client, what types of things are happening that you can share to help real estate agents avoid?
I usually tell real estate agents, don't be too nice.
Oh,
They get themselves in trouble when they're too nice.
okay.
So the two largest, a lot of times they call when they just need help with.
So too nice, like the client says, hey, I'd like a cup of coffee. Get your own coffee.
No, it's more.
Oh, not that kind of
Not
nice.
that nice.
Okay,
It's
got it.
more, which they do though.
Yeah.
Where the seller, for example, needs to have some work done on the home,
Mhm.
either before they list it or as part of the contingencies. And the seller's busy. And so the realtor, because real estate agents are extremely accommodating,
Yes.
will say, I'll go sit at your house while the plumber comes in or whoever comes in. And then what happens is the person comes in, does the work, realtor signs off on it because they're just sitting there.
Mhm.
And then someone comes back, the seller doesn't like it, or they think the contractor did something wrong, or the buyer comes through and says the work wasn't done right. And guess whose name's on that contract that they signed off on the work? And it's all because the realtor's being nice and wasting 3 hours of their day sitting in someone else's house.
Absorb some liability with that, or it's just more tension with your
It's more
seller?
tension with your seller. The liability is limited on that. You're really just doing a favor, but it still causes problems for realtors. And it's not their fault.
No.
They were
it's
just sitting there.
As a real estate agent, though, you want to bring value and say, my value proposition is I'm available and I'm going to help and I'm going to do this. But what you're saying is, even though that's good that you're able to go over and above, sometimes you're going too far over and too far above.
Correct.
And that's what you mean by
That's
too
where
nice.
too nice. Correct.
Okay, that's really good. Thank you for sharing
That
that.
happens.
Yeah, okay, appreciate that. So what do you see buyers suing? I mean, everybody, they love the sue word in this country. What do you see buyers suing sellers about after the sale and closing of the house? And just, I mean, I know you can sue anybody because they don't like the color shirt I have on today, but realistically, like, what do you, in your career, 27 years of practicing law, title, lender, real estate, what do you see buyers suing sellers over?
The two biggest things by far, one is non-disclosure or misrepresentation on the Wisconsin real estate disclosure form.
That dreaded real estate condition report matters, everybody.
Oh, to the nth degree. And the second one is fixtures. What's
Really?
a fixture and what isn't a fixture in a home? Those are the two large, and the real estate agents get blamed all the time and they shouldn't.
So let me ask you this question. I have a framed picture of my cat hanging on the wall. Is that a fixture?
That's not a fixture.
It's hanging on the wall.
Hanging on the wall.
And it's my cat.
It's your cat. So and that's what our poor realtors.
I don't have a cat, full disclosure.
That does not surprise me. Full disclosure on that. What what most realtors, this is why I love realtors. I think realtors are great. I love lenders too, because you have the money.
Yeah,
But
nothing happens till the money shows up.
right.
A lot happens before the
Or
money.
we need that.
That's why we need the real estate agents.
They're great about telling people if it's a fixture and it's something that you want to take. For example, a beautiful chandelier.
That's screwed to the ceiling.
Take it down now. Let's not have a problem later on.
Okay.
And that's the problem, is that people will say, and I've had a lot of realtors call me because there are magnificent fixtures. People have beautiful mirrors that are really literally mounted to the wall. You can't get them down. Beautiful fixed chandeliers, lighting. Take it down. You're selling your house.
Right.
Put up a different electric fan, like all these things that people have. Just take them down.
Okay.
And live in the home, because you're selling it. It's no longer yours. Otherwise, what happens is, with the fixtures, is then there's an issue. So you would then you can list on everyone knows this, on the offer, what's not included. But why would you bother doing that? Just take it down. I had one where there was a screening room. And when I say it was a screening room, it was a movie screening room. When I say mounted, the projector the pictures were amazing. It was up in the ceiling. There's no way you could have taken that down. Everything was mounted to the hilt.
Okay.
And so no one, and I don't blame the realtor. They tried to turn on the realtor. It wasn't the realtor's fault. They didn't put that the system doesn't go with the house. And apparently there was some miscommunication between the buyer and the seller didn't think that they had to leave that.
Oh.
And if I were a realtor, I would have looked at it and said, it's a fixture. You can't get that down. Sure enough, people go to the walkthrough. No big deal. They go to closing. The seller stayed in the house 2 more days. My people walked in. First of all, there was damage to the walls. We're not going to go into the whole thing. And it was gone. And my buyer calls me. He's like, Elisa, that system's gone. That's worth $15,000, $20,000. Get on the phone. Seller said, I never intended to leave that.
Wow.
So, and people were trying to say, well, it should, different people that were involved, because there are a lot of people involved. Oh, the realtor should have put it in. If that isn't a fixture, I don't know what it is.
Bolted to the.
Yeah. Bolted is, yeah.
So I see it when you just explained that, Elisa, I hear a couple problems. One is post-closing occupancy. So they stayed past the house. There wasn't clarity on things, even though it's pretty crystal clear that those were fixtures, but the interpretation of a fixture by that seller is like, hey, this is mine. Right. It's not part of the house, even though legally they were in the wrong. And everyone assumed that to be the case. And then you had the seller stay in the house after the buyer paid for everything. And now the buyer's like, hey, where's my stuff?
Correct.
And now they call you and try to clean up the mess.
Right.
And it usually goes pretty fast, I'm sure. No.
Never.
No.
And it's very expensive.
So
I'm cheap. When I have to hand you off to a litigator, that's when the money has to start rolling in.
Okay. So the fixture, just writing it down, because I suppose what could happen is this. You've got grandma's chandelier that she is part of the heirloom, and you put it in your house. And when you leave, that's my grandma's chandelier. I'm taking it with me. So then you take that fixture down and you wrote it in the contract and you replace it with something you got at Menards that was $29.99. And the seller's like, come on. This was the chandelier that was hanging there, and this is what is on my walkthrough. Talk about that.
So that's why a lot of realtors say to people, get the stuff down now.
Got it.
And put up the cheap stuff so they can see what it is that they're getting, so that they understand. And realtors are very good at this, saying, listen, there was a beautiful magnificent chandelier here, but it's not part of it. We took it down. We put up something. You now can put up whatever you want.
Let me ask you this. So to be a contrarian for a moment, if I'm the listing agent, I want that thing to look as awesome as possible. And that grandma chandelier is an awesome chandelier. So it's to take that down kind of takes away some of that pizzazz.
Then all they have to do, and the realtors know this, is and I agree, there is something to the staging.
Okay.
Then all they have to do is make sure that in that offer to purchase, it says that chandelier that's hanging in this room, and I have people sometimes attach pictures.
That's a great
depending
idea.
What it is, but that's not included in the purchase price.
Got it.
So when you walk through the day of the closing, morning of the closing, or the day before, and we're out, you're going to see a hole in the ceiling.
Okay. Over disclose that.
Oh, I'm big on over disclosure. Yes. Right.
Okay. Let's talk about the dreaded real estate condition report. People fill that out pretty quickly because there's a lot of questions. You go, how big of a deal is that form?
Oh, huge. So Yeah, huge. So what we tell realtors, and they know this, is they are best off to not give any advice at all. They don't know the condition of the home. So they are best if they're, and again, you're trying to be nice because that's how you make your living, right? To be nice to people. The only people that get to be mean and can make a living are lawyers. Everybody else has to be nice. I feel bad for realtors that are in a bad spot.
You're nice for an attorney, though.
Sometimes, not always.
She's nice to me, but I pay her a lot of money.
We do. That at the end of, well, you're nice to me too, though. But at the end of the day, the problem is that the realtor really doesn't know the condition. So what happens is the sellers are notorious for saying, well, what does this mean? And the best thing the realtor can say is, I can walk you through it, but I cannot tell you how to answer it. So a lot of times sellers will say, well, we get a little rain in the basement. Well, everybody gets rain. It's Wisconsin, right? Everybody's going to get water in your basement.
We got a lot of rain this year.
Exactly. But you need to state that. And if the seller doesn't, that's not on the realtor, it's on the seller. So I tell real estate agents, the best you can do is explain to them that they need to state everything, even though it's not always a positive, because you're better off taking care of it now than later. The way that it comes back to the seller, and I always tell sellers, you want to get this all out in the open now. You don't want to leave, and then you're getting sued, because it's real money if you're getting sued. Mm-hmm. So the biggest issue is that this is why that form is so dangerous. Everyone says, well, buyers have to be able to prove that the seller was aware of the defect, they knew of it, and they intentionally withheld the information. Okay. And so sellers think, who's ever going to know? Well, the way they know is because when they call me, when my buyer calls me out of the blue and says, this is what happened, the first thing we always tell them to do is call around and get some bids, like if it's the basement, if it's the foundation, whatever it is, I had a bat infestation, call around and get the people out, get 4 or 5 different groups out. It's amazing what those contractors will say. I was here 4 times in the last 3 years, or I was here 6 months ago. They said they were going to sell the house. We told them to put this, to do that. They didn't do it.
Wow.
Suddenly now, this is going to be easier to prove that the seller was aware. Now, it's going to take time and it's going to cost money because you got to depose all these people, then bring them into court. Just because you're the buyer, other side of this, you're not going to get all your attorney fees back. So it is going to cost you real money to sue on something for misrepresentation.
My question is, what is the timeline? I think that's called the statute of limitations.
You got it.
From closing to when they can actually move.
6 years.
6?
6 years.
Wow, it's longer than I thought.
Has to do with personal property.
Okay.
And there's 6 years. The other side of it is there's a criminal aspect to it where it's theft by contractor if there's considerably more damage.
Okay.
So the options for a buyer, and no one does this, is if it's really serious, you can try to undo the transaction. That's a disaster. Or you can sue for up to 3 times damages.
Okay, so.
But it's a lot of work, a lot of time. You never know what a judge is going to do or anyone else. And it is difficult to prove, but the other one, I had a bat infestation and we went back to the inspector and said, did you not see anything in the attic? Not to blame anyone, but yeah. He said, it looked like mouse droppings to me. I didn't know. And ended up, my guy started talking to the neighbors, like, oh, they've had bats in there for years. They didn't want to pay the $1,200 to have that system put in. So we talked about it. We went back. The seller was being difficult. And I told my client, really, do you want to sue over that? Just pay the $1,200. It's cheaper for you. Just sue for the $1,200.
Wow.
Well, small.
I guess the saying that goes, be sure your sins will find you out, eventually come to the top.
Oh, they do. It's inevitable.
So as the real estate agent, when you're walking through this, you want to just really counsel your client to be transparent and honest on that real estate condition report, right, to reduce their risk.
You're just helping them. The sad thing is that and the realtors have to deal with this. They walk in, it's a beautiful house. They do a lot of work up front. Mm-hmm. And then at the end of the day, then they come to find out is that there's A, B, and C problems. So it's probably going to reduce the purchase price at the end of the day. And everything's got to be disclosed. And so it might be harder for them to market the property then. Okay. So it's hard. It's hard. But the sellers, you've got to be honest. I tell people all the time, buyers and sellers call me, but I get sellers like, I'm not going to disclose this. I'm like, are you crazy? Then don't sleep for the next 6 years because they're going to come back. Wow. They're going to find out what it is at some point. Yes. That all being said, I also tell my buyers, you also need to be proactive. So you need to have an inspection. A lot of people don't want to especially now when there's not a lot of houses, people will, or for a little while, people will forego that inspection contingency. I would never do that. So,
Okay,
hey, do you have your inspection?
you as an attorney would never forego an inspection.
No, there's no house worth it.
Let me ask you this question. So I'm in a bidding war. So the real estate agent advises me to dump the inspection contingency to get the offer because the listing agent said, hey, we got offers with blah, blah, however that, horse trading works behind the scenes. I'm not a real estate agent, so I don't know. And the real estate agent advised them that they've removed that from the offer. They don't put that on the offer. And now it's got foundation problems. Is there liability on the real estate agent?
No, the real estate agent is doing their job by saying to the people, if you want to be in this war and in this bidding war, you're going to need to remove the finance contingency, or sometimes it's fine. I said that because sometimes it's finance contingency or the inspection contingency.
Okay.
So all they're doing is advising the client. So whoever the realtor is, they're saying, listen, we can't even get in the fight if we have an inspection contingency. We need to get rid of that. That's up to the buyer. That's not on the seller. And I have had buyers do that where they come back and try to put that. You're an adult. You need to get an inspection. If not, that's your risk.
That leads me into my next question here. We have a live question that came in, but I'm going to come to that in just a second for those who are watching. The next thing I have on here, in Wisconsin, real estate agents can execute contracts to buy houses and to sell houses. We don't see a lot of attorneys involved in residential contracts. What are some of the reasons as a buyer or as a seller that I want to involve a real estate attorney in the situation? Because what the real estate agents, they can draft the contracts. Right. Title companies have their own attorneys. Right. But as a seller or as a buyer, like in the state of Illinois, it's different. Everybody's got attorneys there. But in Wisconsin, we rarely ever see that. And now all of a sudden, you're submitting an offer without a home inspection contingency. Your realtor's just giving you the information, so they're not liable. Should they consult an attorney and say, hey, what is my liability? What is my risk? And why do people just not do that in Wisconsin?
I'm licensed in Florida too. In Florida, everybody's got an attorney for real estate.
Aside from the real estate agent. So the real estate agent and the attorney work together in Florida. We see that in Illinois.
And real estate agent hate us. I know that most.
Well, I don't think they hate you.
They dislike us because we're the ones who bring up the negative. So I am the one who says to a buyer, I wouldn't do that. But then again, I also, different people tell you different things. I have zero risk tolerance, and I lead with that on every statement I make. I have zero risk tolerance. Now, my firm partner. Mm-hmm. He bought a house without an inspection contingency. So it depends on which lawyer you ask and what the risk tolerance is. But I tell people, you should have the house inspected. Otherwise, just be aware that anything that's wrong, that's on you. Unless they misrepresent, they still have to do the real estate condition report. To me, the inspection is and this, I've talked to real estate agents about this, and they're right. It's a second layer of protection. Okay. So doesn't mean that if I don't have an inspection, that the seller is not liable under that Wisconsin real estate
condition
report. It just means that I haven't done a little bit more work. I haven't done some due diligence.
So if the real estate condition report is maybe less than truthful and there's no attorney, is there such a thing in Wisconsin that's called buyer beware?
There is, and you're an adult. I always say you have to take responsibility.
This adulting thing is hard.
It's hard. It's hard. So I definitely that condition report is key, and nothing eliminates that. That liability is on the seller.
Okay.
But I do tell my buyers you should get an inspection. Now, that being said, when there's a market that's tight, you're still protected under what those sellers said. But I have had a lot of inspections, and I'm sure realtors will agree with me, that they see reports where stuff isn't shown on that disclosure, and then it comes up with an inspector. And then we go back and address it. But it depends on how bad. I always say it's how bad do you want the house and what's your risk tolerance.
And the home inspector's liability is probably limited to his fee, I would think.
It depends on what their contract is. There's different ones. Some of them you can buy a contract with them, like a warranty through them.
Okay.
For it. Listen, those inspections are expensive, especially if it's commercial property or mixed use. But I think it's well worth it. But when you're in a bidding war for something, you really don't have much of an option sometimes.
Okay. We're going to take this live question. Here's the question from one of our viewers. Okay. What legal problems have you seen, Attorney Elisa, with post-closing occupancy?
Okay. Who asked that? That's a brilliant question. Okay.
Well, I don't know. I don't get the names. Sorry. So I just get the questions. Okay.
No, I was going to say, when you were saying we don't use a lot of attorneys in Wisconsin, and we don't. That one of the reasons I do think people should use an attorney is if there's something unusual. So I have a lot of realtors that will call me when they're drafting and say, what about this or that? And I tell them, you don't need to retain me for that, right? I'm cheap, but you don't need me for A, B, and C. And I'll be the first one to tell you, use this language. But if there's going to be post-occupancy, really, and there are forms you can use off of WB, but I do think you should have an attorney draft that because there's a lot of different things that can go wrong. So what if there's damage after the seller has closed, the buyer? I mean, there's insurance issues. Everybody's got your insurance. Got to make sure your homeowner's insurance agent knows that now you've got a tenant for 5 days, 7 days, 30 days.
On an earlier episode, we had insurance agents on here. They said
my favorite people.
Big deal.
Yeah.
Okay. If you don't let your insurance company know that you are not moving in that day,
yep,
and there's post-closing occupancy, you have to let the insurance agent know.
Yeah, I love insurance people because that's your end game to protect you.
Right.
So anytime there's any type of occupancy, the other thing has to do with, is rent going to be paid? What if there's damage then when the seller leaves? What if the seller takes something they shouldn't take afterwards? What if they're not out? Because the question is, if you just have that post-occupancy, how do you evict them then if they don't leave?
Oh my word.
So a lot of times we do
they become squatters?
I do a lease. I say, let's do the post-occupancy. Realtors are real good at putting that language in the offer. And then we say in the offer, we're going to have a separate lease. And I don't care if it's 5 days, 7 days, 30 days, 60 days. Usually got to be out within 60 days. We have language in there on how we get rid of you if you don't nicely leave.
So if there's no language, then it's just like subject to litigation, right? And the judge gets involved.
You don't want to do that, right?
And now, as the buyer of the home, I'm allowing the seller to stay post-closing. I could end up, I'm not really a landlord effectively, right? And now if they don't leave because their new construction house isn't going to be ready now for 6 months, or their dog died and they can't leave the house because little bow wow, whatever reason, and I have to evict them, that could take 6, 7, 8 months.
That's a whole nother ballgame.
And a financial nightmare.
Right. So that's where usually it's nice to have to have an attorney draft that. And I've had realtors that have their buyer retain me just for that.
Okay. So let's talk about the opposite of that.
Okay.
I'm the seller. I've already moved out, sold my house, and this young couple, they
don't ever do that. I tell my clients,
pre-closing occupancy.
Never. Your daughter's laughing. Sorry. No, never. Okay, okay. So here's the thing.
Why not do pre-closing occupancy? That's being nice.
And that's like how about letting the buyer put their stuff in the garage too ahead of time? And then
I see that happen a lot.
Then it doesn't close. Then what do you do? So letting people in, if you're moved out and you've got a buyer that wants then we need a lease and you need to be a landlord and the buyer needs to get tenant insurance, renters, and you need to let your homeowner.
So it's the seller, because I still own the house. I'm just letting you live in my house.
Don't let anybody, it needs to be a lease.
Okay,
because
directly from an attorney.
If the financing doesn't go through, you've got people sitting in your house, you've got to now evict them out.
Well, we just can't tell them to leave?
No.
Doesn't work that way.
Doesn't work.
And now it's January and it's 40 below and trying to get a judge to kick them out on the street.
And it's more, yeah, exactly. And you never know what's going to happen. The other thing is, the big one is letting people use the garage.
We see a lot of stuff. Realtors say, just put it in the garage.
If it falls? Well, because the buyer saying, I need to be able to put my stuff somewhere.
Yeah.
The problem or I'm getting new furniture delivered to my client, and then it doesn't close because you do a check 2 days before, 3 days before, and they don't have a job anymore. You're not going to give them the loan. No. Financing's gone. Now we got a problem.
Full disclosure, that just happened last week. We had a customer quit the job the day before closing. Well, we're closing tomorrow. What's the big deal? Kind of a big deal. You got to be employed the day of closing.
Right.
So
people
that
don't
happens.
listen. So I'm anti that. And I've had people tell me we're not telling you. And I'm like, that's even worse if you don't tell me, because then I can't protect you.
All right. Back to post-closing.
Yeah.
When a post-closing defect issue arises that a buyer or buyer agent believes the seller should have known about, I know sue, lawyer, all that kind of stuff, but what just from a practical standpoint, share it with a realtor when they get the call from their client saying, hey, there's water in the basement. What should the real estate agent do first? Talk to a lawyer, or let me talk to my broker? Or?
Usually what they'll say, and it depends. The first thing we tell people is the same thing the realtors probably say. How bad is it really? Let's be honest. What is it? A little bit? Because there's no home in Wisconsin that's not going to have that. So what's the real issue? Or are they just nitpicking? Because sometimes things don't go the way the buyer thinks, or it's not the way they thought it was going to be.
Or the chandelier they thought they were getting is in there, so now they're mad about the
Just
little bit of water in the basement.
Right. So I always say, and I think most realtors do, call around and get a couple bids to see how serious is it. I will say most of the contractors that I deal with, they're very good about saying this would have happened no matter what. They probably didn't pay attention. It's behind here. It's a little bit of seepage on the wall. Then you have to decide, do I take care of the repair, or is it something, if they lived with a little bit of water for 20 years, what's the big issue?
Fair.
Because the minute you bring in lawyers, I always say to people, you've escalated it. You've escalated it. So I have some people just kind of see if you can take care of it on your own. If not, if it's something serious and you do realize you've got to call around and now you start to get more information and it's serious. At that point, the brokers usually know to walk away, and that's when they refer to an attorney.
Okay.
And then we try to work this out without going to, you do not want to have to go. I don't litigate. I try to resolve it. If not, it goes.
Try to settle everything out.
Somebody out, it's going to cost you way more money.
Once again, my name is James Mercado. I'm the president of ProVisor. You are watching Ask ProVisor. I'm here with attorney Elisa. She's been an attorney for 27 years. She's deemed an expert in lots of issues that we're talking about today. So I have another question for you.
Yeah.
Real estate agents, this is important, so please pay attention and listen. What would you advise a real estate agent to do to protect themselves from getting sued?
The biggest one is not give advice on the real estate condition report. Is
Wow.
not to say, if somebody says to you, well, we get 2 inches of water. If it rains for an hour, we get 2 inches. If it rains for 2 days, we have a foot. Then put that in the disclosure so the people know.
So if I'm the real estate agent, I say, oh, that's not a big deal. We were in Wisconsin. Don't worry about that.
That's where people get themselves in trouble. And the seller is always going to come back to they're always going to blame the agent. We don't. We always say, you're an adult. You filled out the form. I don't see the agent's signature.
So the realtors hold the client accountable, but the client tries to blame the
Right.
real estate
But it's
agent.
it's the client's signature on
Right.
that form.
And they're saying, well, the realtor counseled me or
So they're
advised
better off
me.
not. They're
Okay.
better off. And most of them are very good about saying, I can't give you any advice.
Good.
So if they say things like, are you aware of anything on the roof? And then they say, well, we did have a couple shingles come off last summer. The realtors usually say, then put it on there that you had shingles come off and you didn't replace them. Do it now before later,
That's
before
fair.
you get yourself in
Yep.
trouble. The other thing is, again, don't be too nice. I shouldn't say too nice, but don't be going out on a limb all the time. That thing about repairs gets people in trouble.
Do you see, like,
I've had a couple of those recently.
are there some more common things that real estate agents maybe are not aware of that adversely affect them under some Wisconsin laws? Like, let's say some obscure statute that most realtors didn't even know, and then they end up getting slapped with a letter from a lawyer or anything, or not?
No,
Really?
not really. It's
The
just,
WRA around here does a pretty good
they're
job.
very
don't they?
good. They're very good. And our realtors are trained well.
Yeah,
So, and the people that teach those, I take those classes sometimes, they're very good. So
that's good.
there isn't much. They know what they're doing. It's just trying to be a little too helpful sometimes can get you in trouble.
Okay. All right, here's a big question that I know a lot of our members of our audience are going to want to hear. A buyer has an accepted offer to purchase, and midway through the process, the buyer, financing is all approved, by the way, buyer decides, I don't want the house because little Johnny didn't like something. What have you seen in litigation between sellers and buyers for a breach of contract? When the buyer says, I changed my mind, I don't care. And they just start ghosting every week. They don't respond. They don't care. Sue me, whatever. I mean, what do you do? As a real estate agent, what do you do?
Usually at that point, the realtors, usually if there's a listing agent and a selling agent, they'll talk.
Mhm.
And if the buyer's out, they're out. So then the seller has to decide, what do they want to do? And the realtors know this as well as anyone else. If the sellers sue, they keep their earnest money. Let's go with that. But if the sellers decide to sue the buyer, the problem is it's tied up in court. While it's tied up in court, they can't sell the house. So realtors are better than lawyers when they say, listen, if you sue the buyer for specific performance, which the judge is not going to make them purchase it, but if you were to sue them for that, at the end of the day, you won't be able to sell the house till that's resolved. And the courts are backed up 6 months, 9 months, a year. And what are you really going to gain? What are you out? What some people do is, and the realtors are really, really good at this, saying, let's just move along. Let's sign a cancellation mutual release. You keep the earnest money, but let's move along and get this sold. And then if you, for some reason, let's just say something changes or there's some reason that you get significantly less or there's a problem, right, as a seller, you could then consider, they did breach, even though we signed a mutual release, they breached it. The problem is that you want to be able to sell your house. So you sort of have to remind the seller, it's a breach. It was a terrible thing that they did. They're not good people. You keep the earnest money. But do you want to sit around for a year in that house while we're waiting for the court to hear it? Because you're not going to be able to close on it.
That would be a bad decision.
It's a bad decision.
So what you're saying is, if for some reason after that they get other offers that are considerably less for whatever reason.
Even though you signed the cancellation mutual release, which it gets tricky, my firm partner would disagree, it gets tricky with that. You sometimes have a way to go back in, but it's not, I believe in just moving forward and saving money because you're not going to get much out of it.
Okay. So what I heard you say, and I want to understand this is super important. And from a listing agent's perspective, the more earnest money, the more teeth in the deal.
Exactly. So
when a buyer says, I'll give you $500, like if I'm a listing agent, like, no, you're buying a $400,000 house. I know there's no flat out rule, but as an attorney, what would you say? Is it 1%? Is it, or?
It depends on the transaction, but nobody does 500. Even I just did I just had one, I'm helping with it, $100,000 deal. And I said, we wanted 10,000 there because I'm not sure the buyer's going to qualify for financing. I'm not sure what's going on. So that's a lot of money.
It's because the seller's taking their house off the market.
Right. And they're planning their next move.
Yes.
They're also planning what they're going to do. They don't want to have 2 mortgage payments.
So the exposure for the buyer is their earnest money, but the security for the seller is the earnest money.
Right.
If the thing goes south.
And the theory is that would cover, if they had to cover their mortgage payment plus wherever else that seller's going, because they've got to be out within a certain number of days.
Okay.
So the realtors know what the number is usually for skin in the game. I get them sometimes where I have the buyer, like, I'm not giving them 15 or 20,000 if it's $1 million, whatever. Like, really? You're going to have to.
Yes.
Because then you have nothing. They're not going to take it. There's a reason there's earnest money. And you're right, it's skin in the game.
Okay.
And you get it back if the financing contingency, the inspection contingency doesn't go through, you get it back. Okay. It's just if you breach, if you do something wrong.
Yeah, it's peace of mind for the seller. Right. And makes your offer look more attractive that you're serious.
Yep.
All right, that makes a little bit of sense here. As we're kind of going through all this stuff, it's just like there's just so many layers of complication and so many things for the real estate agent to know, the lender to know, the lawyer to know. This has been super beneficial and super helpful today. I really want to say thank you, Attorney Lisa. Anything else that, like, if I'm sitting here and I'm like, oh my gosh, I have that exact problem, how do they get a hold of you? Like, if they want to contact you just to chat.
The best way to get me is to call me.
Okay.
My number is 262-269-9140.
262-269
9140.
9140. I highly recommend Attorney Elisa. She's amazing. I've worked with her for years, known her a long time, and I'm telling you, she knows what she's doing, and she's very affordable. Not cheap, affordable.
Okay, thanks.
27 years of experience, and she's just very affordable. And I really appreciated that about you.
Oh,
like your knowledge level and that you're always fair. Like, oh, don't worry. That's a simple question. Don't worry about it.
Yeah, if I work with you, then we don't charge you every time.
Love that about you. She's highly recommend her. Highly recommend her. So that's going to wrap up our segment today. I want to encourage you to come back next month. We do this on the second Wednesday of every month at 10 o'clock Central Time. We have similar topics. Next month, we have a special guest, Corey Lamont from the WRA. Corey is the Vice President of Legal and Public Affairs, and you're not going to want to miss this because the WRA, the Wisconsin Realtors Association, is an excellent association, one of the best in the nation. And Corey will be our guest. So get your questions, talk to your other people in your office, talk to your broker, maybe even make it a big deal inside the office for a viewing party or something. But Corey will be on next month for us to answer a bunch of questions. Once again, my name is James Mercado. I'm the president of ProVisor. We are an independent mortgage banking firm. We have the ability to close fast. We have extremely low rates, and we have very low fees. One of the advantages of working with us is we're locally owned and locally operated. So if you ever need a second opinion, it doesn't cost anything. We give second opinions for free. Thank you for watching. Make it a great day, everybody. Thank you, Attorney Lisa.
Thank you.
You're welcome.